Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my private Facebook group, which is Foreclosure Help 777. And if you're in foreclosure or you need help with your foreclosure or have questions, you can join my private group where you can talk with other like-minded people, and we are here to help each other fight our foreclosures. Okay, so today's topic is something everyone needs to, gain a better understanding of, and that's case law. So we're going to talk about case law today. Case law is something that you're going to have to really have a good understanding of if you're going to fight foreclosure, and it's probably, if not the most important thing when you're writing your motions. So let's get started. Okay, so I made this little presentation to help you guys out. It's about case law, why it matters in foreclosure defense. What is case law? Written opinions issued by judges that interpret statutes, contracts, and prior cases. Why it matters. Judges decide based on precedent, not just statutes. If you don't cite case law, the other side will. Analogy. Statutes are like rules of the game. Case law is how referees, judges, interpret those rules in real life. Binding versus persuasive authority. Binding means decisions from the same jurisdiction, higher courts. In other words, let's go with New York Appellate Division rulings are binding on lower courts, like trial courts. So the higher the court, the more binding the case is. Persuasive, decisions from other jurisdictions or lower courts that a judge may find convincing but is not required by law. And a pro tip, always start with binding cases, then add persuasive ones if helpful. Hierarchy of the courts. The trial court is the lowest. Then you have your appellate division. Court of Appeals is the highest in the state. Federal courts can provide persuasive authority on foreclosure-related issues, but state foreclosure law is usually governed by state statutes and state appellate rulings. How case law shapes foreclosure. Key foreclosure issues that are controlled by precedent. In other words, let's look at some of these here. Standing, when a bank doesn't have standing. Wells Fargo versus Yapkowitz, that's a 2021 case. Strict compliance with the 90-day notice rules means the bank doesn't have standing. Statute limitations, Freedom Mortgage versus Engel. As we know, after so many years they can't foreclose. Res judicata, prior dismissals, prior foreclosure dismissed on RPAPL 1304 or statute of limitations grounds can bar new actions. Void assignments. Courts have dismissed where assignments were into dissolved trust, like IndyMac Full Service Bank versus Measles. Defective notices. Many states like New York and New Jersey strictly enforce notice requirements. Failure equals dismissal. Okay, so how to use case law as a pro se litigant. First of all, you want to read the actual case, not just a blog or a website. Quote the holding, not random language. Holding equals the court's actual legal rule decision. Apply the facts. Show how your situation matches the case facts. Update. Check that the case hasn't been overruled. You can use Google Scholar or you can use Sentient is a good one. Common pitfalls to avoid. Relying on out-of-state cases where you have in-state precedent. In other words, if your case is in, say, Virginia, you don't want to use a case, say, in Texas because it's out of state. Another pitfall is using trial-level decisions as if they were binding, citing pseudo-law sources like sovereign citizen-style websites. Judges instantly dismiss those. Failing to distinguish published versus unpublished opinions. Unpublished may have limited or no precedential value, so keep that in mind too. Practical tips for foreclosure fighters. Keep a case law library. Save copies of key rulings in your state. Learn to search using Google Scholar or Sentient. If you have access to Westlaw or some of the other ones like Nexus, Lexis, then you can also use those. Organized by issue, standing, assignments, notices, statute of limitations, jurisdiction. Always connect case law to your facts. Just like in the Engel case, my loan was accelerated in 2017 and not deaccelerated, so this foreclosure is time barred. So you have to use your case to fit your situation. Why judges respect case law arguments. It shows you've done your homework. Forces the judge to engage with binding precedent. It levels the playing field against bank attorneys who rely on boilerplate. It makes your papers look professional, not just emotional. Practical tips for citing case law. Always use the full citation the first time. Example, Mitchell versus Armstrong Capital Corp. is 911 SW 2D 169 to 171, and it's Texas Appellate Houston 1st District 1995 writ denied. After that, you can shorten it, Mitchell 911 SW 2D at 171. Why? It shows professionalism and makes it easy for the judge to locate the case. Pinpoint your pages. Don't just cite the case, cite the exact page where the holding is. Example, the court held that if a genuine issue of title exists, the Justice Court lacks jurisdiction. And Mitchell 911 SW 2D at 171. Why? Judges appreciate precision. It also prevents the other side from saying you misquoted. Connect the law to your facts. Don't just drop the case name, explain how it applies. Just like in Mitchell, where the court lacks jurisdiction over title dispute and a forcible detainer, here the existence of competing assignments creates a genuine issue of title. Why? Judges want to see the bridge between precedent and your case. Stick to binding authority first. Use cases from your state's appellate or Supreme Courts. Out-of-state cases can be persuasive, but they're secondary. Example, in New York, 2nd Department Appellate Division controls trial courts in Brooklyn. Why? A judge is bound to follow higher court rulings in your jurisdiction. Use case law sparingly but powerfully. Quality is better than quantity, guys. 2 to 3 strong, directly on point cases are better than dumping 15 weak ones. Why? Judges don't want case dumps, they want clarity. Quote the holding, not the fluff. Find the holding, legal rule, not just the background discussion. Good. The court held that the defective 90-day notice requires dismissal. Bad. The court noted in passing that the notices should be properly mailed. Why? Only holdings carry precedential weight. So, the other one's not binding. Always shepherdize. Check if the case is still good law. So, in other words, you want to use a secondary source and have it double check everything. Be consistent with the formatting. You want to italicize or underline the case names. I use italicize, it looks better. Always include the reporter plus the page plus the court plus the year. Makes it look professional and credible. Use parentheses if you need to, as this one has, and that, as you can see, in 2021, it's in parentheses, holding that acceleration is triggered by filing a foreclosure complaint. Also in parentheses. Why? It saves the judge time and reinforces your argument. Don't over-rely on unpublished cases, guys. That's a big mistake people make. Okay. Now let's take a look at how to properly read a case citation, guys. I think a lot of people don't know this and need to know this. We're going to use Mitchell versus Armstrong Capital Corp. again, as it's a good example. And this is how it looks, guys. Let's break it down so you understand this. Mitchell versus Armstrong Capital Corp. are the parties involved. Mitchell is the appellant. Armstrong Capital is the appellee or the bank. 911 SW2D 169171. This is what you guys need to know. Published in volume 911 of the Southwestern Reporter, the second series, starting on page 169 with cited text on 171. So that's where those numbers come from, guys. And it says Texas Appellate. Okay, so it's decided by the 1st District of Texas Court of Appeals in Houston, and the year was 1995. The writ was denied. The Texas Supreme Court denied review. This appellate decision stands as final. In other words, this case was remanded back because JP courts do not have jurisdiction to adjudicate any title disputes. Okay, breakdown. Again, this is just going over what we just said. Why it matters. When you cite this case in Texas, it's a binding precedent on trial courts in Harris County. That's why it's a good one, guys. Because the Texas Supreme Court denied review, the ruling stands as good law, and nobody's overruled that one, by the way. The key holdings in Mitchell, the foreclosing party must have the legal right to enforce the note and deed of trust. An assignment defect or lack of standing can make the foreclosure invalid. Texas courts strictly enforce proof of ownership of the debt before foreclosure. How to apply it. When using this case, you'd argue, just like in Mitchell versus Armstrong Capital Court, the plaintiff here cannot establish standing because the assignment was defective and the trust no longer existed, or the note wasn't properly endorsed. Without proof of ownership, foreclosure cannot proceed. And again, that's just showing you how that's, can be worked. Okay, let's take a look at something else. If you're going to make a memorandum of law in support of whatever motion you're filing, you're going to want to write a good table of authorities. And so this is probably, I think, the best way it looks in most cases. You want your table of authorities, the title at the top. You want cases and page or page numbers. And sometimes you'll have more than one page number if you cite it more than once. As you can see here, the first case is Bank of New York Mellon versus Craig, and right under that and tabbed over is the actual case citation, 169 AD 3D 627, 2nd Department, 2019, and this is New York. And you see how they all look nice and neat. Everything's really good and orderly here. And then right after the cases, you have your statutes and rules, which is, in this case, in Carrington's brief, it goes over all of these you have to have in there as well. And so after this memorandum was done, it's going to go to be checked over by, if you're going to write a memorandum of law, you want to check it with Sentient. Okay, so I go to Sentient, CETIENT. It's probably the best case law cross-reference system out there. It's not too expensive. It's like $5 a month, so it's worth it. So if you ask it a question, I would say, can you look at this memorandum of law and tell me if the case exists and is on point? Okay, so it's thinking about what I sent it. It's going through all these cases. This is nice because it not only goes through each case, it tells you whether it exists and if it's on point. And it tells you if there's any of them that aren't on point or don't exist. And then if you need to swap one, you can ask it to find one that you can swap it with. Alright, so it's saying here, and it's going through here, saying, below is a concise verification of each authority cited in defendant supplemental memorandum. For every case, statute, or rule have confirmed it means it exists, it provides the link to the official source, etc. So this is another way you can read each case as you Sentient, and you can click on each one. It says yes, yes, yes. So these cases do exist, and on-point analysis, you see? It tells you not only if each case exists, but if it's on point. And then at the end, it will give you an overall assessment on your cases. All cited authorities exist, and the holdings are directly on point for the arguments raised in the supplemental memorandum. So you can see it's a way of double checking your stuff to make sure you don't get dinged by the judge or the other side. It's really important, guys, that your case law is on point and it exists, and that you're correctly citing it in your stuff. Okay, I hope this was informational and helpful to you guys. And if you have any questions, you can always send me an email. My email address is foreclosurehelp777@gmail.com. I hope everyone has a blessed day.